Welcome to Law Talk NH Unfiltered, your go-to source for clear, practical insights into New Hampshire law. I'm Brian Stone, solo practitioner and founder of Stone Law PLLC, where I focus on criminal defense and family law to protect your rights and help you navigate tough legal situations. Now, today's episode covers domestic violence restraining orders in New Hampshire. What they are, how they work, and what you should know if you or someone you care about is involved. Whether you're seeking a restraining order or responding to one, I'll break down the key points so you can understand your rights and options. If you have questions or need legal help, you can reach me directly at contact.stonelaw@gmail.com. Now, let's get started. Every domestic violence action requires notice to the other party. In domestic violence cases, the judge specifically has to be careful to ensure that the defendant receives adequate notice of the allegations from the plaintiff. That's the person filing the domestic violence restraining petition. And that's because a lot of these cases, usually when they're brought forward, it's brought forward by a self-represented party. And usually the judge might issue what are called ex parte temporary protective orders. That means only one side was heard. Usually how this notice is provided is that order, if a temporary order is issued, will get forwarded to the local police department. And then the police department will find the defendant, that's the person who the domestic violence restraining order is being filed against, to give them that order or the notice of the hearing, or both. Now, RSA 173-B1 provides protection from domestic violence. And this is where you get your domestic violence restraining order from. It has a broad range of protections for a broad range of persons. Now, let's first talk about what domestic violence is under the statute. So under RSA, domestic violence, first of all, they define it as abuse. Abuse means the commission or attempted commission of one or more of the following acts by a family or household member or current, former sexual or intimate partner, where such conduct constitutes a credible present threat to the plaintiff's safety. So what that means is it can be family members, household members, can be ex-girlfriend, ex-boyfriend, current partner, could be strictly romantic partner. It doesn't require any sort of sexual relationship. And what the court considers of evidence of abuse within the domestic violence statute are things like assault, reckless conduct, criminal threatening, sexual assault, interference with freedom, could also be stalking, that's included, destruction of property, unauthorized entry, and harassment. And that's harassment, not the general sense that people think of, it's harassment under RSA 614. It also includes cruelty to their animals, so just be aware of that. And the person filing their contact with the defendant during the time frame of the alleged abuse is not going to preclude a finding that the defendant poses a credible and present threat to the plaintiff's safety. So again, we've defined abuse. We've gone over part one. So we need one or more of the following acts we just went over. Okay, that's part one. And it has to be someone that meets that special relationship with the person filing. The last part is that conduct needs to also constitute a credible, present threat to the plaintiff's safety. So it has to be credible and it has to be present. So if it's not a present danger, then a judge will not issue a temporary order and will certainly not issue a final. So usually how these cases go is the individual filing will go to the courthouse where they live or where the defendant lives, whichever jurisdiction, they can pick either one, or where they're currently temporarily residing. If they've fled from the defendant, they can go to that courthouse and they'll file what's called a domestic violence petition. And in that petition, they'll list the information of the defendant, the petitioner's own information, which can be kept confidential from the defendant, and they'll list their allegations. And their allegations have to fit within the statute of what constitutes abuse. Now, usually in most cases, the person's pro se, so they don't have an attorney. They don't know what they have to write down. So they're not necessarily referencing the statute. They're also filling this under oath, so they can't lie. If they lie, they'll be charged with perjury. The other thing is they can't, people will list everything under the sun. They'll say, oh, well, we've been in a relationship for years. I don't like this. I don't like this about them. They do this. They'll talk about things that are not relevant to the petition. So relevance is important. If it's not relevant, the other party, the defendant, or the defendant's attorney can move to strike those parts of the petition, which means get rid of them. So the court can't consider them at any sort of hearing. And that's because they're not relevant. They have nothing to do with the petition. They might have something to do with the relationship, obviously, and the history between the parties. But if it doesn't hit on one of those defined terms of abuse, then it is not relevant. It has nothing, it muddles the issues. It's steering the court away from what it needs to consider. When the person's at the courthouse, they usually have to be at the courthouse. The only way they can avoid being at the courthouse is if there's some sort of medical reason they can't be there. It can be done over the phone. It can be electronically transmitted to the courthouse in extreme special circumstances. But generally, when the person goes to the courthouse, they fill this out with a court clerk. These court clerks are trained to go over the paperwork with the plaintiff. And when the plaintiff's done filling that out, that day, a judge is going to look at that petition. They're going to make an order on it. They're going to decide the following things. They're going to decide, is there enough written in this petition that it meets the definitions? If it doesn't, the judge will throw out the petition that day. If it does, the judge may say, okay, there's abuse, but maybe there isn't enough here to show me that the defendant constitutes a credible present threat to the plaintiff's safety. I need to hear more. And what they'll do is they won't issue temporary orders. They'll just schedule the matter for a final hearing. And at that hearing, think of that as like the trial. That'll be an evidentiary hearing. And at that hearing, the burden is on the plaintiff to convince the judge that there's abuse, that the person meets the relationship definitions, and they're a credible present threat to the plaintiff's safety that day. If they're not, the judge is supposed to throw it out. Now, obviously, the defendant will be at this hearing, but if they're not, that doesn't necessarily mean they lose. The burden is still on the plaintiff. The plaintiff still has to make their case to the judge. The other thing is the judge could, when it's filed, find that there's abuse and the allegations show that the defendant constitutes a credible present threat to the plaintiff's safety. Now, the judge isn't deciding necessarily that that's a fact. They're deciding that the allegations in the petition are sufficient. You have to remember, this is an emergency thing that's being done here. So the judge isn't necessarily going to hear from the defendant unless the defendant gets wind of what's going on and they happen to be at the courthouse at the same exact moment. So what'll happen if the judge finds everything's good, they'll issue temporary orders. Now, these act as a restraining order. It's temporary in nature until the final hearing. So it's not a forever order. And let's say it's the weekend, or maybe it's after hours, courthouse is closed at 4 p.m., and somebody wants to file a restraining order. Now, what they have to do is they have to contact law enforcement and go over the paperwork with law enforcement. And what law enforcement will do is they'll call a judge to get a telephonic order, to get a verbal order. And then that order is always temporary in nature. Any orders after hours, they're only good until the end of the next business day in court. So let's say somebody files for one Sunday, it's ordered, temporary order. That person has to file a formal petition all over again at their courthouse before the end of business on Monday. If they don't, by the end of business on Monday, that temporary restraining order is gone. It's no longer in effect. Another thing that can happen when someone's at court and they file the petition is a judge will look at it, of course. The judge is not prohibited from speaking person to person with the plaintiff. So the judge is allowed to say, here's what I need. Can you explain more about this thing in your petition? They can't tell the person what to write, but they can the plaintiff on what the judge would need to grant a temporary order, or at least schedule the matter for a final hearing. So there can be a lot of back and forth. It can be denied by the judge. Just remember, if it's denied by the judge, that doesn't mean that the plaintiff can't file one the next day if there's something else that happens. If there's something else that's happened, they can file it again. There's an unlimited number of times they can file these petitions. When these orders are in effect, usually the person, the defendant, has to be notified. They have to have what's called adequate notice. So they will know. They'll get a copy of the petition from the police. They'll get told if there's temporary orders. They'll be told when the final hearing is. And those temporary orders, and usually there are temporary orders, will tell them what they can't do. And usually what they can't do, obviously, is they can't have contact in any sort of way, including through third parties, with the plaintiff. They could be required to stay out of their own home because usually when it's a domestic violence case, the parties share a home. So that can be difficult for a defendant. So the parties, let's say they live together, they're married in a marital home, temporary orders usually say you can't be at the plaintiff's home, and that could be your home. So you could be forced to stay with family or in a hotel during those temporary orders. You cannot be even at your own home. They'll be required to turn over any deadly weapons, any machete, nunchucks, firearms, all have to be turned over to law enforcement. You may also have to stay away from the plaintiff's family members, anywhere they may be, could include their workplace. Let's go back to adequate notice. So the petition itself is going to list the allegations of the plaintiff. Those allegations have to be communicated to the defendant. So he or she can get ready for their hearing so they can defend themselves. They need to know what the allegations are. That means at that final hearing, the plaintiff is not permitted to testify or introduce any sort of evidence about something that's not in the petition. And that's because the defendant does not have adequate notice. Prior to the final hearing, what a plaintiff can do is they can make amendments to their petition, which means they can add things to their petition. Usually this happens if the person obtains an attorney and that attorney is looking through their petition. They might have amendments to try to tweak it a little or add some new information to increase the odds of success. Even if an amendment is made, the defendant still requires adequate notice. That means the defendant needs to be notified of these amendments and have adequate time to prepare a defense. Let's say an amendment is made the day of the final hearing, or maybe the day before. The defendant may object and say that they do not have adequate notice. So adequate notice requires more than just informing the defendant. It requires informing them, giving them adequate time to prepare a defense. So the defendant may argue a few hours or a day's notice is not a proper amount of time to prepare an adequate defense, depending on what those amendments are. The other thing is the timing of this hearing. Remember, if the judge issues temporary orders until a final hearing, the rights of the defendant are being restricted. They're being restricted based merely off the allegations of the plaintiff. Remember, the plaintiff can write whatever they want. They can lie, even though it's illegal. There's nothing preventing them from doing it. There's no way when that temporary order is issued for the judge to really delve through whether the allegations are true or not. All that's necessary is that the person alleges the right things. Because of that, the rights of the defendant cannot be restrained, like their right to bear arms, their right to go back to their home even, or maybe even go to their workplace if these individuals work at the same location for an indefinite period of time. New Hampshire law states that if someone files the petition and the court is going to schedule it for a final hearing, that final hearing has a strict deadline. It must occur within 30 days of that petition being filed. That means if the court's schedule has other things going on, those other things are going to have to be rearranged to accommodate that 30-day deadline. In a lot of instances, the court does not do that, and the defendant may not even be aware of that. It's very common for these final hearings to occur much later than 30 days. They could occur 50 days later. It's very common. The court will just schedule it that way. it's incumbent upon the defendant to assert their right that it must be within 30 days. The other thing is the defendant also has the right to not even have this temporary order, if there are temporary orders issued, hanging over their head, or even just the stigma of knowing that there is a final hearing coming up, that there's a domestic violence petition case out in the ether hanging over their head. What they can do is they can request a hearing, that final hearing, to be within 5 days, so much sooner, but they have to make that request in writing via what's called a motion. They have to make a motion to the court to have that hearing within 5 days. And that hearing cannot be sooner than 3 days, but it has to be within 5 days. So it could be 4 days after, 5 days after. It cannot be 2 days after, 3 days after. At these final hearings, the burden, as I said before, is on the plaintiff. So they have to introduce evidence through witnesses, exhibits, those are documents they may want to introduce, and they have to testify. They have to testify about their allegations. They may be asked questions by their attorney on the stand. Whatever they testify to, the defendant has the right to what's called cross-examination. That means the defendant or the defendant's attorney can now ask the petitioner, the plaintiff, questions about what is in their petition and what they were asked about on what's called direct examination or their direct testimony from the beginning. And the point of cross-examination is to whittle through the issues. Did these allegations actually occur? Are they really the way that the plaintiff is trying to characterize them? Is there a genuine fear that the plaintiff has of the other individual? Are there some other motives behind filing the petition? So a lot of times, these petitions are filed to get a jump start on the other individual for a divorce, a criminal matter. This could be the prelude, and it's an improper way to use the domestic violence restraining orders. These domestic violence restraining orders were designed to protect people from imminent danger by another party. However, a lot of people use them to get a leg up on the other party, especially if they're married and they're getting a divorce or they have children in common and there's a parenting action that's going to occur or has just started in the family court. For example, let's say somebody has been wanting to get divorced for a long time. They get in some sort of argument. Maybe there's some sort of domestic violence. Maybe there isn't. They file this petition. At the final hearing, if they win that final hearing, the other individual now has a domestic violence restraining order against them for at least 1 year. After that 1 year, the plaintiff can come back to the court before that 1 year expires and request that the domestic violence restraining order be extended. And it can be extended for another year. It can be extended for up to 5 years. Now remember, at this final hearing, there will be final orders if the petition is granted. These final orders can cover things such as who gets possession of a marital home, who has to pay what bills, who gets to see the kids and when, who gets to make decisions about the kids and when, who has to pay to support who. So it can basically act as a divorce decree in a sense. And the longer that this order is in effect, whenever a divorce action happens, the judge in the divorce case is going to see that the other person has a domestic violence restraining order against them. It doesn't start them off in a great light with the divorce judge. And whatever those orders are usually what the judge in the divorce case might go with as part of a temporary order in the divorce case until the parties are actually divorced. And in a divorce case, whatever orders a judge issues in the divorce case, they don't change the orders in the domestic violence restraining order. What that defendant has to do is they have to motion the court and or judge in the domestic violence restraining order case to amend the domestic violence restraining order so that they can carry out the temporary orders and or the final orders in a divorce matter. For example, let's say the parties end up getting divorced and this person has the domestic violence restraining order against them. And the divorce decree has a parenting plan, and it says the defendant can see his children on Fridays. But the domestic violence restraining order says he has to stay away from the children. Now, in order for the defendant in the domestic violence restraining order case to be able to see his children, even though there's a court order saying he can see his children in his divorce case, he needs to go back to the court case where he has the domestic violence restraining order and make a motion to the judge for an amendment to change that domestic violence restraining order so he can see his children to carry out the temporary orders or the final orders for the divorce case. And until that happens, that individual cannot see his children. The domestic violence restraining order either has to go away or be amended. And if this is hanging over someone's head in a divorce case, it can be used as a negotiation tactic. It can be used as a bargaining chip, because the plaintiff in the plaintiff in the domestic violence restraining order case has a chip they can use now. In the divorce case, they can say, hey, I want this. If you do this, I'll drop the restraining order. Even though the restraining order might be ordered for a year or longer, the plaintiff in the domestic violence restraining order case can get rid of the domestic violence restraining order whenever they want. They can go to court at any time and get rid of the domestic violence restraining order for any reason they want, whenever they feel like it. And this can put someone on a poor negotiating standing if they have one against them and they're in a divorce case. It can really tear away at somebody. Now, at that final hearing in the domestic violence restraining order, the defendant can put on their own evidence. So they can introduce their own documents. They can have their own witnesses testify. They can even testify themselves. But testifying yourself is usually not advisable because remember, the plaintiff has made allegations of abuse. These definitions of what constitutes abuse are also crimes. So these hearings are all recorded. They're on the record. So you might want to exercise your right to remain silent, because anything you say at this hearing will most certainly be used against you by law enforcement and or by the plaintiff's attorney in some shape or form. It's not uncommon for there to be a criminal case about the same issue, or a criminal case that may be instituted. Maybe law enforcement just hasn't decided if they want to charge the person. And it's not uncommon for law enforcement or a prosecutor to even show up at a domestic violence restraining order hearing. Sometimes they show up and take notes and they're paying attention to what people are saying. The other issue with these domestic violence restraining orders, especially for service members, is you are prohibited from possessing weapons. If you're prohibited from possessing weapons, you're not going to be in the military for very long. If you have the final domestic violence restraining order granted, you will be discharged from the military. And that's because there's a federal law, it's called the Lautenberg Amendment, especially if you're convicted of a crime for domestic violence, that prohibits you from serving in the military. So something like a domestic violence restraining order, even a temporary order, most certainly a final order, even if it's just for a year, can be a career ender for some people. It can ruin their entire lives. And these are things a plaintiff, in my experience, usually doesn't think about, especially if the parties are married, or even if they're not. The plaintiff may not want such severe consequences for the defendant, even if they have a case and their allegations are true. Maybe a plaintiff can't foresee that they're going to ruin someone's career, make them lose their home. What I notice for married parties, even if they're getting divorced, it's not necessarily in a plaintiff's interest to have the other person, the defendant, lose their job. They lose their job, they can't really support the plaintiff in any sort of temporary orders in a divorce case. They can't pay the bills. Maybe they can't pay the mortgage. Maybe they can't pay child support. And these are all things that plaintiffs frequently overlook and do not consider. A lot of the time, they're laser focused on anger or revenge. They're not thinking about the rest of their lives. So in many circumstances, the interests that are being harmed by an order being granted are not just against the defendant. they frequently will impact the plaintiff in negative ways, especially if the parties are married and or have children in common with one another. Now, the standard at this final hearing is not like a criminal case, because remember, while there may be a criminal case about the allegations, this case, the domestic violence restraining order case, is a civil case. So the legal standard is much lower at the hearing. There are no rules of evidence at the hearing. So normally in a criminal case, there are these things called the rules of evidence. In order to introduce something to the court, the party has to follow rules. In a domestic violence restraining order hearing, there are no rules. The judge can consider anything they want. They can also exclude things they want. The rules of evidence can be used as a guideline by the judge. The judge is not bound to follow those rules whatsoever. A big one that the judges will usually always follow is they will usually not allow hearsay testimony. That's someone like the plaintiff saying somebody else said something. That person would usually have to be required to be in court and or testifying. If the orders are granted, like I said, it can have dire consequences. If the orders are granted on a final basis, that person, the defendant who has this final restraining order against them, is now exposed in a legal sense. They're exposed in a sense that if they violate any of the terms, even inadvertently, such as, let's say the defendant happens to be in the same coffee shop by accident of where the plaintiff is, they have technically violated the restraining order. Violating the restraining order is a crime. It is a Class A misdemeanor. It carries up to a year in jail and a monetary fine. It is also a domestic violence crime, which can be a career ender. It's also something, if you're convicted, you cannot annul off your criminal record for 10 years after the completion of your sentence. That is a long time. It also exposes a defendant to false allegations by the plaintiff. These things can be weaponized in many, many ways. These orders issued by the judge, remember, the judge has to be convinced. There is no jury, it is just the judge. And the judge has that final hearing to assess the credibility of the plaintiff. The judge is looking at the plaintiff's face when they're making statements, asking questions. The judge is assessing whether these allegations are true. Is there a credible fear? Is the defendant really a danger to this other person? And so forth. Sometimes, if the other party has an attorney and they know the parties are getting divorced, usually you can tell by the petition if it's just the couple just doesn't get along anymore and this is really a divorce case. If a divorce action is going to be filed, sometimes you can get a civil restraining order in a divorce case, which is just an order in the divorce matter saying, hey, stay away from this person. And that doesn't have criminal penalties, but it does have sanctions if you violate it from that divorce judge. This is usually a better option if there's not really a threat to the other person's safety and that person just wants, the other person, maybe they just want them out of the house while they're getting divorced. Maybe they just want them to leave them alone. Usually that's a better option. That way they don't have this domestic violence restraining order hanging over their head. Permissible contact. Now, an attorney or any person acting on the attorney's behalf who's representing the defendant in the domestic violence case is not prohibited from contacting the plaintiff for a legitimate purpose within the scope of that proceeding. However, most attorneys, including myself, are not going to contact the plaintiff in a domestic violence restraining order case unless they have an attorney. And what we're going to do is we're going to contact their attorney, because that can make up any story they want about what I talked to them about. And that is just simply not worth the risk. Usually if I have a conversation with the plaintiff, it's going to be in front of the judge if that person doesn't have an attorney. Or I'm going to get very specific permission from the judge about the nature of the conversation. And if I do have that conversation, I'm going to have a witness with me in the room, on the phone, whatever it may be. And it's unfortunate because a lot of these plaintiffs are pro se. They are not represented. So it's very hard for the attorney for the defendant to try to see if things can be resolved without necessitating the final hearing. Because a lot of these problems can be resolved. A lot of them are just usually marital disputes or parental disputes, and they're things that have gotten out of hand, and they don't necessarily meet the requirements of abuse under the domestic violence statute. And even if they do, it may not be exactly what the plaintiff wants to do in their own interest. These orders, people have to think practically. They're not going to stop someone from committing further acts of abuse. At the end of the day, these orders, whether they're temporary or final in nature, do not stop somebody from doing anything. They are just pieces of paper at the end of the day. And that's something a plaintiff needs to be cognizant of. They also need to be cognizant of what that order will say and how it'll impact the defendant. It could make things worse, and that's something only the plaintiff can really know and can make an assessment of. But they should know that there are going to be consequences for the defendant. If the defendant's a very violent person and you get that restraining order saying they can't go back to their home or see their children, things could get even worse. These are all things a plaintiff needs to think about. And in a best case scenario, they should think about it with the advice of an attorney. These cases can be transferred to another court, and that's usually upon motion by a party or, as the interests of justice or the convenience of the parties might require. The receiving court, though, still needs to have jurisdiction to hear the case. For example, let's say the plaintiff lives in a different jurisdiction with a different courthouse, defendant lives in a different jurisdiction with the courthouse. Maybe the courthouse of the defendant is actually closer to the plaintiff, but the plaintiff had originally filed in the courthouse in their jurisdiction rather than where the defendant lives. Either party or both of them can request that they change it to the defendant's courthouse because that might be more convenient for both parties to drive to. Might be convenient for their attorneys. These are things that can happen, but it can't arbitrarily be a random courthouse that none of the parties have ties to. It's, the courthouse in a completely different county where the plaintiff's not temporarily residing, the plaintiff didn't reside at, the defendant doesn't reside at, that will not be within the jurisdiction of that court to hear the case. So it cannot be transferred to that courthouse. Other things to consider. Firearms. A lot of people think when they have these orders granted on a temporary basis or a final basis are living with friends, relatives. Those relatives, friends, own firearms. If the defendant is in a house and there are firearms in that house and they are unsecured, meaning that defendant, even though the gun's not on them, they could pick it up, they could walk into someone's bedroom and pick up the gun, they have constructive possession of that firearm. They're violating the restraining order. They can be put in jail for violating that restraining order. It is a crime. So it doesn't require the person to have the firearm on them. In instances like that, a way to get around that is to have those firearms stored in a gun safe that the defendant doesn't have access to, doesn't know the combination to, or they're stored somewhere else. Another thing a defendant can do is they can transfer the firearms that they own, they can give them to someone else rather than having the police have their firearms. If the police have someone's firearms for a year or longer, what they're going to do is they're going to start charging the defendant to store the firearms, or they may destroy the firearms if other arrangements cannot be made. And firearms can be very expensive. Some people have a lot of firearms. It's something defendants need to be cognizant of. People also need to be aware of if there's a temporary order or final restraining order, that is an order from the court. You cannot violate that order in any shape or form. People forget that the plaintiff does not control the order. That means if the plaintiff contacts the defendant should not be contacting the plaintiff or think that the order no longer applies. The order applies until there is a subsequent court order getting rid of that order. So for example, if the plaintiff is texting the defendant wanting to make up and talk to them, the defendant cannot respond in any shape or form. If they do, they are violating the restraining order. That is regardless of how the plaintiff feels about it. What the plaintiff would need to do is get rid of the restraining order in the first place or seek an amendment to the restraining order so that the parties can talk to each other about certain specific things in a specific way. For example, if the parties need to discuss childcare, an amendment should be made in the order that says the parties can talk about childcare only, and it should specify the medium. For example, childcare only via text or email only. And that's to protect both parties to, one, make sure there's no violations, and two, to make sure there's no false allegations against the defendant. These restraining orders apply anywhere in the country. They technically apply anywhere on the planet. So if you are in Florida and you have a restraining order issued in New Hampshire, you cannot violate it just because you're in Florida. Now, the judges in these cases, they have to be unbiased and impartial to determine the issues put forth. And that impartiality is set out in the New Hampshire Constitution. That's Part 1, Article 35. It's also a Supreme Court rule. So that's Supreme Court Rule 38. So if there's any issue about the judge, sometimes there is. Sometimes the judge might know one of the parties. Sometimes the judge might know someone who's associated with the party that could touch on the judge's impartiality. That should be worked out between the parties in the court, and sometimes another judge might need to sit in on the case to ensure that they are absolutely unbiased and they are impartial. The expedited hearing I went over earlier, where the defendant can request a hearing no less than 3 and no more than 5 business days from the request, while there has to be a hearing, that hearing doesn't have to be a final hearing. That can be overlooked, and it commonly is overlooked. It can just be a hearing, just to say, hey, just to touch base and schedule a final hearing another time. Another thing about the deadlines is that the general 30 days can be extended for an additional 10 days upon motion from the plaintiff or the defendant for what's called good cause shown. That means a very, very, very good reason. For example, there's a final hearing scheduled on such and such date. Defendant's attorney can't attend because the defendant's attorney is having an emergency surgery that day. Then an additional 10 days can be put forward to reschedule that final hearing. So good cause does not mean any reason. It has to be a very, very good reason. And again, it is the court's policy that domestic violence cases will take priority over other cases without time requirements. Now remember, there are also other types of restraining orders. What we're going over today is just the domestic violence restraining order. And this is usually the type of restraining order that packs the most punch because they are criminal in nature. If someone violates it, there are criminal penalties. It carries a lot of weight. Other types of restraining orders are usually civil in nature. That means there are penalties, there are legal penalties, but they are not criminal penalties for a violation. So these domestic violence restraining orders carry a lot of weight. Again, thanks for listening to Law Talk NH Unfiltered. If you or someone you know needs help with domestic violence restraining orders or any other legal issue, feel free to reach out to me at contact.stonelaw@gmail.com. I'm here to provide clear, straightforward legal advice and representation tailored to your situation. Be sure to subscribe so you don't miss future episodes about New Hampshire law. And stay safe, stay informed. Until next time, I'm Brian Stone.